The purposes in view. This is the heart of the public purpose. So you can read that and sort of, my notes to the margins out here are basically to help you understand what this is. Okay. And then method of procedure. So each legislative body shall provide for the manner in which such regulations and restrictions and boundaries of each district shall be determined. City Council has to vote on it. They recognized early on that this would not be a static thing for all time, that Peachtree Street began its life as a residential street, that likely it would change over time. That in 1811, if you had zoned Manhattan for what it was in 1811, then we wouldn't have Manhattan today, right? So they made provisions for change. These may be amended, supplemented, changed, modified, or repealed, so on and so forth. Then for the establishment of a zoning commission, this is, originally you did not have departments or bureaus of planning, so you established a citizen commission, typically composed of real estate developers, architects, city planners, landscape architects, lawyers, to review these things and to make a preliminary report and hold public hearings before submitting its final report to the legislative body. And then you have a board of adjustments. This is what I was talking about earlier, that where you have a case of hardship, you cannot, for some reason having to do with the configuration of the lot or some particular aspect of the parcel, cannot conform to the zoning. It's impossible to do so. I had to get a variance to rebuild my garage because it was sitting on the property line. If I had moved it over 7 feet, which was what was required, I would not have been able to get my car in the garage or out of the garage, right? It would have run into the corner of my kitchen. So that was my hardship. So this creates then the Board of Adjustments. And this enumerates the powers that they may have. So you can see that a good bit of this is in fact procedural. Again, this goes to the heart of equal protection of the law, sort of having common procedures, protocols, language, so on and so forth. Conflict with other laws. So the test case was Euclid versus Ambler. The Ambler Realty owned 2 parcels, a parcel here between what is now Interstate 90, so actually the Nickel Plate Road in the village of Euclid, which was just outside the city of Cleveland, and a second parcel here, which the city had zoned U2, and within that zone they were only allowed to construct residential buildings. The Ambler Realty sued, saying that they were entitled to just compensation, that the city of Euclid or the village of Euclid had to, in fact, compensate them for the difference in value between the sale of the property as industrial property and the sale of the property as residential property. Industrial property would sell for more, right? And they won in the lower court. This is actually sort of what it looks like. There's the parcel that was zoned U2, residential. There's a detail of it. Lying between 2 railroads for the entire length of the village area, extending some distance to either side of the north and south, having an average width of about 1,600 feet, so on and so forth. So this is the actual case. You're expected to read this case. I have highlighted in red or in blue or with notes in the margins certain interpretations or parts that I think are critical. So the ordinance divided the village of Euclid into 6 classes of use, denominated U1 to U6, 3 classes of height, H1 to H3, and 4 classes of area, denominated A1 to A4. Frankly, in my opinion, this is a terrible ordinance, and I wish they had selected a better test case, because this one got everything all balled up from the get-go. Very rarely do you have these overlapping districts like this in a modern zoning ordinance. In terms of height, they said, look, this is well established. You have ladders, fire equipment that reaches a certain height, so it's perfectly within the city's exercise of police power to limit the heights of buildings based upon fire equipment, right? The area districts, here the ordinance reaches over into subdivision regulations, which are properly part of the city planning enabling statute. This is my comment. The problem is that the test case, this one, was heard by the court prior to the passage of the city planning enabling statute. And so they didn't really untangle the fact that they had two things conflated here. And as I said, this has caused us problems, I think, to this day with all zoning issues. Putting all sorts of things on zoning that properly belong somewhere else. And then the ordinance is assailed on the grounds that it is a derogation of Section 1 of the 14th Amendment to the Federal Constitution, and that it deprives the Ambler Realty Company, the appellee, of liberty and property without due process of law, and denies it the equal protection of the law, and offends against certain provisions of the Constitution of the state of Ohio. The prayer of this bill is for an injunction restraining the enforcement of the ordinance and all attempts to impose or maintain it as regards the appellees, that's Ambler's property, any of the restrictions, limitations, or conditions. The lower court held this ordinance to be unconstitutional and void and enjoined its enforcement. Okay? So before proceeding then to a consideration of the case, and this is where reading these cases gets interesting. This is the logic of the court, of the majority opinion of the court. It says, before we get into the specifics of this, it's necessary to determine the scope of the inquiry. The bill alleges that the tract of land in question is vacant and has been held for years for the purpose of selling and developing it for industrial uses for which it is especially adapted, being immediately in the path of progressive industrial development. That for such uses, it has a market value of about $10,000 per acre, but if the use is limited to residential purposes, the market value is not in excess of $2,500 an acre. So, Village of Euclid, compensate us. And if I was Ambler, I would have done exactly the same thing, right? I want to be compensated for the difference. The court says then, it is specifically averred that the ordinance attempts to restrict and control the lawful uses of appellee's land so as to confiscate and destroy a great part of its value, that it is being enforced in accordance with its terms, that prospective buyers of land for industrial, commercial, and residential uses in the Metropolitan District of Cleveland are deterred from buying any part of this land because of the existence of the ordinance and the necessity thereby entailed of conducting burdensome and expensive litigation in order to vindicate the right to use the land for lawful and legitimate purposes. That the ordinance constitutes a cloud upon the land, reduces and destroys its value, and has the effect of diverting the normal industrial, commercial, and residential development thereof to other less favorable locations. Okay? So the record goes no further than to show, here they're citing the lower court, saying, as the lower court found that the normal and reasonably to be expected use and development of that part of appellee's land adjoining Euclid Avenue is for general trade and commercial purposes, particularly retail stores and like establishments, and that the normal and reasonably to be expected use and development of the residue of the land is for industrial and trade purposes. Whatever injury is inflicted by the mere existence and threatened enforcement of the ordinance is due to restrictions in respect of these and similar uses, to which perhaps should be added, if not included, in the foregoing restrictions in respect of apartment houses. Specifically, there is nothing in the record to suggest that any damage results from the presence in the ordinance of those restrictions relating to churches, schools, libraries, other public and semi-public buildings. Now, let me comment there that by definition, you do not zone public land. Zoning is what? The restriction of use of private property. Now, the city of Atlanta has zoned Piedmont Park. Okay? It doesn't make any sense to zone Piedmont Park, but they have zoned it for residential use. And when I raised that with the Bureau of Planning, they said, we got to zone it something. No, read the Euclid case. No. Okay? So the argument by the court is that building zone laws are of modern origin. They began about 25 years ago. Until recent years, urban life was comparatively simple. But with the great increase in concentration of population, problems have developed and constantly are developing, which require and will continue to require additional restrictions in respect to the use and occupation of private land in urban communities. They go further to say that, in fact, in terms of the equal protection aspect of the 14th Amendment, that the law does not single out Ambler specifically. There was no specific damage to the plaintiff, right? That it was attached to the land, and it was based upon a duly written ordinance passed by the legislative body and signed into law by the mayor. And therefore, the court is loath to intervene where you have a law that has been duly passed by a city council, a municipal government, constitutional body in a legal way. Then they cite precedents, including the famous slaughterhouse cases in Louisiana, so on and so forth, and they overturned the lower court decision upholding that the Euclid case is in fact a lawful exercise of the police power provisions. 2 points I want to make. The court will not disaggregate, pull apart the specific provisions of this law, but we will consider the zoning ordinance as a single body of law. In other words, a case that is now probably 8-10 years old, but which is more recent that you may have heard of, the Supreme Court decision in the affirmative action cases at the University of Michigan on their admissions policies, where they pulled the cases apart and considered them as two separate cases, considering the undergraduate admissions policy of the university as one set of issues, and then the law school admissions policy as another set of issues, in which case they ruled that the university undergraduate admissions, in fact, was a violation of the Equal Protection Clause of the 14th Amendment, but that the law school admissions policy was not, right? They pulled them apart. In this case, they considered it as one thing. Then finally, the second is that, and this is very typical of Supreme Court decisions, the courts are loath to substitute their judgment for that of the legally constituted legislative and executive branches of government as to the specifics of the law's provisions. The court's role is to determine whether these laws, either in their provisions or in the way that they are applied, violates the federal Constitution. It is not their decision to sort of say, well, we think U1 should have really been U2, or that the height limit should have been 38 feet, not 36 feet. You follow me? They don't like to substitute their judgment for that. And that became important in this particular case because they said, we're not going to get into the specifics of this. What we are going to do is to consider this as whether or not it is in fact a violation of the 5th and the 14th Amendments arising under the Due Process Clause of the Constitution as applied to the exercise of the flexible powers of police with which we are here concerned. And they reversed the decision of the lower court, in this case the Supreme Court of the state of Ohio, and upheld the legality of zoning for the village of Euclid. And I think it was actually then found to be a legal and valid exercise of constitutional police power. Now, This is just something I put together from my own curiosity and then thought that it might be useful in the context of this course, since we're talking about urban form, how cities developed, looking at Euclid in Cleveland, which is on the south shore of Lake Erie, one of the Great Lakes. We see these blue wagon roads. The shoreline here is black. This would have been, let's say, 1785 at the time of the passage of the Land Ordinance, which subdivided all of the territory west of the Ohio River up into township and range with 160-acre quarter sections and 40-acre, I guess those would be quarter of a quarter section, whatever that is, a quarter of a quarter, 40 acres. The section, of course, being 1 square mile, an array 6 by 6 sections would equal a political jurisdiction called a township. And then we see here the Nickel Plate or the Lakeshore Railroad coming through, and then the Nickel Plate Railroad comes through here. And then we see the parcels here that were owned by the Ambler Realty Company that were under scrutiny in this case. And then the interstate is put in paralleling the rail lines. It's often the case that the interstate highways, when they were built in the 1950s and 60s, paralleled railroad lines for a variety of reasons. So there you actually see an aerial of this with the 160-acre quarter section that you see here, and then the interstate highways and the 2 railroads. All right. Now, the courts, the Supreme Court has a history in a decision like this where new law is being made through the decision. In this case, the new law being zoning, of opening up the window and then sort of closing it back down but leaving a little crack, meaning we're going to rule the penumbra, the shadow of our decision will be wide and far-reaching, but actually the scope of the decision has a little crack. And what they're doing is inviting a second case to come in, and they're sort of, it's a tacit admission that this maybe wasn't the best test case, that there were still issues to be debated and resolved. And they have a history of doing that. They've done that with all sorts of legislation. And this is a case where they did that. And a second case appeared before them in 1928, which is called Necto versus the City of Cambridge. Now, Cambridge, Massachusetts, being part of New England, is under a sort of very different structure than we are here or the rest of the United States is. So there are terms in this case which may be unfamiliar to you, like the master. They have in their state legal processes, they have something which, even before the courts, which resembles arbitration. And by that I mean that the court will appoint a master to sort of do research on a finding of fact and then make a recommendation to the court. So it's a little bit different, where the judges themselves are actually getting a sort of a brief from an appointed individual who has researched all of the facts in the case. This particular case, the Necto case, actually then closed that window back down a little bit, actually substantially. We used to live in Cambridge, Massachusetts, so actually when I was studying this case, I was able to go and look at this particular parcel, although I don't have any photographs of it. This is MIT, we see right here, and a railroad track coming in here. And this is a kind of an industrial area that we see here that includes the New England Confectionery Company that make wafers called Necco, N-E-C-C-O, Necco wafers. You ever seen this candy? Necco wafers. And they still tell stories there about the day in 1896 when the Necco factory exploded was during a snowstorm, and all this chocolate went up and mixed in with the storm clouds, and it snowed chocolate. And so you can imagine all the children who were excited about not having to go to school or something that particular day had a double delight because it was actually raining chocolate flakes. You can imagine, really be great, right? Well, what had happened is that the city of Cambridge had passed a zoning ordinance in which, to the left of Brookline Street, here on the map, was all residential, and everything between here and the railroad tracks was sort of industrial, including the Necco factory, which was a little further up. And the city then zoned this industrial and zoned this residential. Mr. Necto owned a garage. He was a mechanic, and he worked on automobiles in the early days of automobiles, the 1920s. And so he had a whole lot of junked cars hanging around on his lot that he would pirate these old broken down cars for parts that might still be good, right? The engine on a particular car might be no good, but the radiator might still be good. And so he would pull the radiator out of a car and so forth. And the city zoned this parcel that was owned by Necto, part residential, you see here, and zoned part of this as for commercial uses. And Necto sued, saying that in effect this was a taking of his property, that he needed the whole thing for the operation of his garage, and thus it was taking away value, basically the same argument that Ambler made in the Euclid case. The court, this is actually commercial and residential, I got it backwards, I'm sorry. The court, citing the Euclid case, ruled in favor, this is the state court, this is Massachusetts court, ruled in favor of the city of Cambridge, that in effect it was, citing here the characters, that considered by this court in the Euclid versus Ambler, in its general scope, it is conceded to be constitutional within that decision. So this is a Supreme Court case. This is the majority opinion that you're reading. And you will see that actually here they are citing their earlier decision in Euclid. And they're saying that in the Euclid case, the court left open the possibility that a specific application of the law could be an invalid use of police power, and thus a violation of 5th and 14th Amendments. So Necto lost in the lower court and appealed, and it went to the Supreme Court in 1928. That's what you're looking at here. The long and short of this is the U.S. Supreme Court overturned the lower court, saying in effect that while the intent of the law was not to be a violation of 5th and the 14th, that actually they had followed the protocols of the enabling statutes, et cetera, just as the village of Euclid had done. But in the specific application of the law, where this particular piece of property, here in red, was zoned to two different things, it was a violation of the 5th and the 14th, that it denied Necto his due process rights. Now, to take this further, and this is not in the comment, this is my commentary. In effect, what the zoning ordinance did was to create a de facto subdivision, right? It zoned one parcel of land, two different things with a line drawn down the middle of the property, saying that in fact one side could be used for commercial and the other side for residential. I was involved in a zoning case back in 1983 where it got built. It was a condominium, two identical apartment buildings, owner-occupied, so condominium. And it's on North Highland Avenue near the Aurora, I think it's Aurora Coffee Company. It's not Aurora, it's DBA Barbecue. You know where that is. And it was a very strange parcel of land with 110 feet of frontage on North Highland, adjacent to commercial property on one side and a photographer's studio on the other. Even though the photographer's studio had been built as a single-family residence, it had been converted into commercial use, Lee Photography. The city had zoned the front half of the parcel commercial and the back half of the parcel residential. I was familiar, of course, with the Necto case, and we went before the Zoning Review Board where we were defeated about 368 to nothing. I mean, people had, you know, our pictures on buttons with X's through them, things like that, right? Foaming at the mouth. And we were just slam dunked. I mean, it was a unanimous decision by the Citizen Advisory Board to deny the rezoning. Well, I was familiar with this case, so I looked it up and I took it to the attorney who was representing my client and said, you might want to read this case and then have a conversation, have lunch with the city attorney. Because if you want to take this to court, we will win. You cannot zone one parcel two different things. Simply put, can't do it. It's a de facto subdivision. It is not land use. And that was the issue here, and the judgment was of the lower court was reversed, and Necto was able, in fact, with compensatory damages paid by the city, was able to maintain his garage, his use of the property. Okay, so there are, remember, two different issues. One is the regulation of private property here, zoning, and the other is the City Planning Enabling Act, which came along in 1928, which in fact controls the subdivision of land. Taking undifferentiated territory and subdividing it up into streets and blocks and lots with parks and public spaces and public buildings and other kinds of things like that. And as we will see, the area that we're in right here was originally a private subdivision. Most American cities were built that way, where a landowner subdivides the land and then sells off improved lots. To this day, that is basically how subdivision developers still operate. There may be a few companies, large companies, national companies, but it's a very small percentage of the total single-family residential development in the United States, less than 10%. 90% of all single-family housing is actually built by people who build fewer than 10 houses per year. And typically what they will do is purchase the lot, the improved lot, from the subdivision builder. So the subdivider is putting in improved streets, running utilities, sewer connection, water, and his or her product is in fact that is sold on the market, in the marketplace, is in fact the improved lot. In some cases, Back Bay in Boston, the city itself acted as the developer, with the state fronting the money for the construction, if you recall, of the Charles Street bulkhead and the construction of the public gardens, in which then the proceeds, the revenue, and then the second one, which was there's Arlington Street, and then the B Street, Berkeley, and the proceeds of the sale of those lots between Arlington and Berkeley was used to then build the 3rd Street, Clarendon, right, and so forth. This is the city acting as a developer, but normally it is a private firm or individual who will subdivide the land. And then the streets and the utilities and so forth are turned over to the public entity for maintenance. The subdivisions like Inman Park, Druid Hills, Ansley Park, Brookwood Hills, and so forth, the early subdivisions in Atlanta were built exactly that way. And then the city is responsible for the maintenance of the streets, which you pay property taxes and so forth for. So these streets and so forth have to be built to a particular standard. And that standard is set by the municipality under the provisions of the subdivision regulations, which fall within the Standard City Planning Enabling Act. And so this deals with the acts of subdivision. Now, let me fast forward to the present and say that over the last ever how many years it's been since 1930, what would that be, 83 years, these issues of sort of constitution and representation, to use the terms that I've coined for this course, are hopelessly conflated, right? They become all mixed up and confused in everybody's mind to such an extent that the city of Atlanta, as I mentioned, has actually zoned Piedmont Park, a public space, has actually zoned it, which by definition doesn't make any sense, by definition. They've even zoned freeway rights of way. You know, if you've got an exchange with a circular access ramp, the land in the middle of that circular access ramp will actually show up as a zoning category, you know, residential or commercial or something, which makes absolutely no sense whatsoever. But that's how hopelessly confused these things have become. So I thought it would be useful for a brief moment to go back and look at Section 6 of the General Powers and Duties of the Standard City Planning Enabling Statute as it was passed out of Congress in 1928. In this case, the commission is the City Plan Commission, which in the early days was typically a citizen body that consisted of architects and landscape architects and city planners, lawyers, real estate developers, citizens, you know, activists, so forth, who would then constitute this commission. Today, this is typically the Bureau of Planning within city government, within municipal government. So either way, that's what commission is referring to. So their duty and function is to make and adopt a master plan for the physical development of the municipality, including any areas outside of its boundaries, which in their judgment bear relation to the planning of such a municipality. Well, that was a mistake, to put it kindly. I don't believe that the city of Decatur, Georgia, would take very kindly to the city of Atlanta making plans for how the city of Decatur should be developed. Right? Likewise, I don't think the city of Atlanta would take kindly to the city of Sandy Springs making plans for how Atlanta should be developed. The people who are elected to serve on the Atlanta City Council are duly elected constitutional officers charged with the making of laws, et cetera, and so on. So this was a mistake. But let's look at what the elements of such a plan were in the original enabling statutes. Such a plan with its accompanying maps, plats, charts, and descriptive matter shall show the Commission's recommendations for the development of the territory, including, among other things, the general location, character, and extent of streets, viaducts, subways, bridges, waterways, waterfronts, boulevards, parkways, playgrounds, squares, parks, aviation fields, and other public ways, grounds, and open spaces, the general location of public buildings and other public property, and the general location and extent of public utilities and terminals, whether publicly or privately owned or operated, and so forth. Also for the removal, relocation, widening, narrowing, vacating, abandoning, change of use or extension of any of the foregoing ways, grounds, open spaces, etc., as well as a zoning plan. The idea being that you project out what the public parts of the municipality will be, and then you pass the zoning plan based upon the rational use of land, based upon the capacity of the streets and the sewers and so forth. Unfortunately, that is not how it has unfolded, and it has created a large mess, to put it in technical terms. It's a mess. Now, let's hold that in abeyance for the moment and continue on then with zoning. After the Necto case through World War II, there were very few cases. Part of this may have had to do with the Great Depression. There was not a lot of development, real estate development going on in the 1930s. There were a few cases. I've already mentioned the clothesline cases in Ohio. And then one, which is actually fairly critical, McCarthy versus Manhattan Beach. Manhattan Beach is a incorporated town on the Pacific Ocean in the greater Los Angeles area. It is to Los Angeles as, let's say, Decatur would be to Atlanta. And under the boardwalk, down on the pier in Manhattan Beach, all these kids would congregate. Now, these are people that are probably at present old enough to be your great-grandparents if they're still alive, and they would get down there and drink beer and smoke cigarettes and fool around and do other things that upset the general public. And so Manhattan Beach passed a zoning ordinance which actually forbid the sale of any alcoholic beverages, cigarettes, other kinds of things that were attracting these youth who were down under the pier carrying on. And the court ruled, in my opinion correctly, that this was not a valid use of zoning. That zoning could not be used as a surrogate for enforcement of other laws, regardless of whether or not it was in the public interest. Right? Yes, it may be in the public interest that these young people are not down there carousing and drinking and doing all sorts of things. However, that's not a zoning issue. If the drinking age is 21, enforce the Open Container Act, enforce the Drinking Age Act, enforce the existing laws that address the specific behavior, but you cannot use zoning as a surrogate to solve some other kind of problem. This is really kind of an extension of the Necto case in a way, right? In the application of the law, zoning deals with land use, and it does not deal with as a surrogate for other laws, regardless of whether or not it was deemed in the public interest. Well, those were really the only two sort of major cases that came along until the late 1950s and early 1960s, when there was a series, almost rapid fire, 62, 74, 77, so forth, 78, 79, that all involved 14th Amendment, that is, equal protection cases. 1962, a suburb of Pittsburgh, duly incorporated, passed a zoning ordinance in which they zoned every single thing in the town residential with a minimum lot size of 4 acres. A developer, joined by the National Association for the Advancement of Colored People, the NAACP, sued. The Pennsylvania Supreme Court, citing an invisible plaintiff, ruled that such zoning was exclusionary. That is, that it violated the 14th Amendment rights of African Americans. Now, they did so on the grounds that it froze forever the possibility of a city to change and grow as it might actually need to do. As a result, they incited then this invisible plaintiff. And just to point this out, the developer was saying, you know, I mean, there's not a market. The market for a whole town full of 4-acre lots does not, in fact, exist. Right? So with the NAACP joining the suit, it then kicked it immediately into a suspect category and a fundamental interest, and thus it was heard by the Pennsylvania Supreme Court, which overturned Easttown's zoning ordinance, saying that you can't zone every single thing in the town one use. Just logic just dictates that that is absurd, and that in fact it would potentially violate future generations yet unborn, who would not then be able to move into this town because they can't afford to buy 4 acres of land. Let me point out here that there's a bit of a convoluted sort of logic to this, brilliant on the part of the attorneys. And that is that there is no constitutional guarantee to income. Nowhere. There is a higher number, in absolute numbers, of ethnic white people who are below the poverty line than ethnic black people. However, as a group, there is a higher percentage of African Americans below the poverty line, particularly in 1962, than there are ethnic whites. And therefore, it became then this 14th Amendment equal protection issue. Following on that, in 1974, Southern Burlington County NAACP versus the Township of Mount Laurel. Mount Laurel is a legally incorporated town in southern New Jersey, directly across the river. It's a suburb of Philadelphia. And the NAACP of Southern Burlington County sued Mount Laurel on the basis that Mount Laurel had done something similar. It wasn't quite as absurd as zoning everything 4-acre lots, but it was something similar. What made this case particularly interesting is that the mayor of Mount Laurel was African American and a majority of the city council was African American. And so the court in this case is ruling not on the intent to discriminate, but by the application of the law. Again, going back to NECTO, in the application of it, it was discriminatory because Mount Laurel, as part of the Philadelphia metropolitan area, had a responsibility to provide its fair share of different housing types for different income groups and so on and so forth. And then finally in 1977, Arlington Heights versus the Metropolitan Housing Corporation. This is a complicated case, and I think it's best if we just ignore it, to tell you the truth. However, I would encourage you to read this slide carefully, because there will be test questions on this particular slide. So now I'm going to do what no teacher should ever do. I now have one thing in abeyance, that is the subdivision regulations. I'm going to ask you to hold a second thing in abeyance, which are these equal protection cases. And I want to introduce a third element here, which is called the American Association of Highway Transportation Officials, AASHTO. This is a voluntary association of all the state departments of transportation. All right? They set the standards for street design in what is known as the Green Book. And if you have $500 lying around, you can go online and buy it. There is a copy in our library. It's a manual for the geometric design of streets and highways and so forth. And now we're going to come back here to Spring Street and Fifth Street. And if you are from China or Korea or France or anywhere else in the world, this is a reason why you should proceed cautiously and carefully when you sort of look to anything in the United States as an example of how to do something. because what we've created here is a total mess. This street, West Peachtree, is a state highway. It was not built by the state. It was built by a private subdivision developer. But when the interstates were built, it connected one part of the interstate to another part of the interstate. And thus the state took it over. And so state law and state DOT applies to West Peachtree and Spring Street. Okay? Fifth Street, from this intersection to Spring Street, is owned by the City of Atlanta. Fifth Street from the Georgia Tech Hotel to the freeway, the bridge across the interstate, is owned by the City of Atlanta. And then it crosses the right-of-way of the interstate highway, which is owned by the state of Georgia, built to AASHTO standards. So to get a common sidewalk at Tech Square took 2 years. 2 years. Now, if you were a private developer trying to develop the Georgia Tech Hotel or this building or anything else on this property, you don't have 2 years. Your pockets aren't that deep. You can't sit on your loans for 2 years waiting on approval from the state and approval from the city. And the state and the city would never agree because they operate on two sets of standards. The Midtown Business Association, which created an organization called Midtown Alliance, had done a plan for Midtown in which they had developed a standard sidewalk, a standard curb cut for wheelchair access, etc. That's standard light fixture for the streets, etc. But the state did not recognize that. Included in the city's plan, or in the Midtown Alliance plan, which was adopted lock, stock, and barrel completely by the City of Atlanta. They just incorporated all the Midtown Alliance standards and guidelines into their public works standards. The city streets could have on-street parking, but the state said you cannot have on-street parking on a state highway. And that because this was designated under the AASHTO standards as a level 1 service road, it meant that you could only signal it every 1,800 feet. So you couldn't have stop signs. You couldn't have traffic lights every 1,800 feet. So the state and the city never could agree. Well, if Georgia Tech, which doesn't have particularly deep pockets, but which is not going to go anywhere, we're here for the long haul, had not been involved, then it is doubtful that we would have a standard sidewalk, the same sidewalk that we see on 5th Street and the same sidewalk that we see on Spring or West Peachtree. We would have had, in fact, different standards. In fact, David Green, some of you may know, he is professor of practice. He's an architect, urban designer with Perkins and Will, professor of practice in the College of Architecture, working for a private client, developed this housing project called Mid-City Lofts over here. And they never could get a certificate of occupancy so that people could move into the building because of this problem between the city and the state. And ultimately, Georgia Tech was able to break that logjam, and there was an agreement reached on the sidewalk details. But you understand that you're moving from state to city to state to city to the state again, and then to a city street that runs through a state institution, Georgia Tech. However, where you have fraternities and sororities fronting onto that street, they are private entities, and that's private property. Okay? The state is not subject, Georgia Tech is not subject to zoning law. Now, it tries its best to conform to it because it doesn't want to have a headline in the Atlanta Journal-Constitution saying Georgia Tech refuses to abide by city law, right? So they will do their best to abide by it. In any event, the developer over here, Kim King and Associates, of this housing, didn't have the same wherewithal that Georgia Tech has, and so they had a real problem there. And ultimately, it was resolved so that they could actually then get on-street parking on West Peachtree Street, which the state was not going to allow. AASHTO has subsequently, in the last 10 years, developed something called context-sensitive design, because they have recognized that if you're building sort of rural highways, level 1 service may mean something quite different than it does, in the middle of Midtown Atlanta. They haven't gone far enough, but I wanted to mention this because it is, in fact, I'll say here, together with zoning and subdivision regulations, these standards are the most powerful agents of design of contemporary urban and suburban form in the United States today. And it's incredibly powerful. I mentioned earlier carrot and stick. If you want to get federal money for whatever it may be, the development of freeways or something, you have to conform to federal DOT standards. And the federal DOT has adopted the AASHTO standards as the standards actually that we have to live with. So much of Stein and Wright's initial Radburn ideas were incorporated into these standards. They tend to favor cul-de-sac streets. They tend to favor, in fact, the nomenclature of streets of local and collector and distributor and arterial. Every subdivision regulation of every municipality in the country has to use those terms. So if you think about that, the concept of a boulevard or the concept of a parkway or the concept of an avenue does not fit within these standards. This doesn't fit. Is Ponce de Leon, as it goes through Druid Hills toward Decatur, is that a collector, a distributor? There's nothing within the classification nomenclature of AASHTO that would allow a street to have any larger social, economic, or political purpose beyond the safe travel of automobiles and trucks, bicycles. Does that make sense to everybody? Okay. It's not within their purview, right? So, I've had arguments with people, planning director of Columbus, Georgia, who I said, these gorgeous streets that extend through a 19th century, the downtown of Columbus extends these streets, same width, same right-of-way, extends into these residential zones, absolutely beautiful streets, marvelous neighborhoods. And I pointed out that under the subdivision regulations of whatever county that is, it's a consolidated city-county government, anyway, that I could not build an avenue. He said, yes, you can. I said, no, I can't. He said, no, you can. You tell me what kind of street you want to build and you negotiate with me. And so my response to him was, so you're telling me that as a developer, as a property owner, my 5th and 14th Amendment rights depend upon your willingness to agree with me. That is what the courts would say is an arbitrary and capricious use of police power. It's not the rule of an individual. It's the rule of law. So if I have a standard that says I can only signal every 1,800 feet, I cannot stamp a drawing that has it signaled every 600 feet, right? I cannot knowingly violate the law. I'd lose my license. He's still convinced he's right, I'm sure. I hope he doesn't find out the hard way in a court that he is in fact wrong. So these two pages actually summarize, what you will be responsible for on the test. Okay, zoning. That date is wrong. That should be 1926 right there. I also think this from the Mount Laurel case summarizes the court's position in an extraordinary way. It's a liberal court, and it never was tested at any higher level. But the New Jersey Supreme Court in 1983, there were actually two cases. The first one said, look, Mount Laurel, you are responsible. We're not questioning whether or not your intent is honorable and so on, but you are responsible for your fair share of a multiplicity of land uses and housing types within the greater metropolitan Philadelphia area. Even though you're across the river in New Jersey, you are still part of the standard metropolitan statistical area of Philadelphia. And they wrote, it would be useful to remind ourselves that the doctrine does not arise from some theoretical analysis of our Constitution, but rather from underlying concepts of fundamental fairness in the exercise of governmental power. The basis for the constitutional obligation is simple. The state controls the use of land, all of the land. And exercising that control, it cannot favor rich over poor. It cannot legislatively set aside dilapidated housing in urban ghettos for the poor and decent housing elsewhere for everyone else. The government that controls the land represents everyone. Right? Everyone. Okay.